event today. Here's some of the big ticket cases from the previous term. You might have heard there were some newsworthy cases. I don't know if you guys follow them at all, but we've got some great experts here to present them to us. So, to my right, we have Mr. Michael Berry. He's the Vice President of External Affairs, Director of Military Affairs, and Senior Counsel for First Liberty Institute. As a recognized subject matter expert on religious liberty, Mr. Berry has testified before Congress and is routinely invited to speak across the nation about religious. Mr. Berry has also been featured hundreds of times in various national media outlets. Prior to joining First Liberty in 2013, he served for 7 years on active duty as an attorney with the U.S. Marine Corps. Among Mr. Berry's numerous positions within the Marine Corps, he deployed to Afghanistan in 2008. And from 2009 to 2012, Mr. Berry served as an adjunct professor of law at the United States State Academy. Mr. Berry also earned his bachelor's from Texas A&M and his law degree from the Ohio State University. And then Professor Josh Blackman is a national thought leader on constitutional law and United States Supreme Court issues. He regularly appears on national TV, including CBS, NBC, and Fox, and is a frequent guest on NPR and other syndicated radio programs. Professor Blackman is also a prolific writer. He has authored 3 books, published more than 6 law review articles that have been cited nearly 1,000 times, and written for leading publications like New York Times and the Wall Street Journal. Professor Blackman teaches at South Texas College of Law in Houston and serves as an adjunct professor at the Cato Institute. He received his bachelor's degree from Penn State and his law degree from George Mason University. Please join me in welcoming our great speakers.
And I highly recommend that you read Professor Blackman's posts on about various Supreme Court cases and even lower court cases, because I find them to be very enlightening, informative, and I often use them as sort of cheat sheets for myself when I'm trying to figure out what's going on.
He's a real lawyer. I just play one on TV.
So I think this is actually the first time I've shared
I think that's right.
the stage with you, Josh. So I'm very pleased to do that too. So I think in terms of the way we're going to have this set up for the next hour or so is I'm going to start by giving a 30,000-foot view, basically via what I call the Supreme Court stat pack. I'm a huge fan of and proponent of fantasy football. I've even recently gotten into fantasy Premier League soccer. So I'm a little bit of a data geek. I haven't yet figured out the Supreme Court analogy to wins over replacement, but I'm trying to figure that out. So, but then Josh will talk. We'll start digging into some of the cases, and then I think you said you were going to cover abortion and guns.
Nothing big, just the small stuff.
Yeah, the boring stuff, and then I'll sort of back clean up with religious freedom cases at the court. So just in terms of the 2022 term stats, starting big, there were 66 cases decided in total. 58 were signed opinions and argued cases. There are 3 per curiam opinions in unargued cases, 2 per curiams in argued cases, 2 digs. Does anyone know what a dig is?
The shovel, right?
Yeah.
You bury it? No.
So nobody? All right. So it was now I'm forgetting the acronym. Improvidently granted.
Dismissed as improvidently granted.
That's right. And then once, in other words, we should not have granted cert in this case. So we're, and then one interesting 4-4 affirmance in an argument case. So one of the justices obviously recused and ended up in a 4-4 tie. When that happens, it's just whatever the decision of the lower court remains. Trends, right? I'm going to go through these quickly, so I apologize. We only have an hour, and I want to make sure I leave enough time to talk about cases and answer any questions. So if I'm breezing through, there's a reason. I'm happy to provide this afterwards if anybody actually wants the numbers. But some key trends that I noticed in the past term. Only 29% of cases were decided unanimously. That's the lowest rate in 2 decades, right? The lowest unanimous decision rate in 20 years. 30% of the cases were 6-3 decisions. You're probably going to hear 6-3 as a 6-3 and 5-4 sort of a trend. Of those 6-3 decisions, nearly 3/4 of them, so nearly 75% of the 6-3 decisions were along straight party lines. Chief Justice Roberts and Justice Kavanaugh were in the majority in 95% of the cases, and Justice Barrett was in the majority 90% of the cases. I'm going to come back to that in a minute. Justice Sotomayor was in the majority in only 58% of the cases, And in divided cases, she was only in the majority 41% of the time. Contrast that with the Obama, her tenure on the court during the Obama administration, in which Justice Sotomayor was in the majority 89%, 83%, and 93% of the time, respectively. What's the key takeaway there? Elections matter, and they actually have an impact. Bonus, since we're here at SMU, the Texas Solicitor General, Judd Stone, tied for the most argued cases with the U.S. Solicitor General. Each of them argued 5 cases. Another interesting freebie is that these were actually Solicitor General Stone's first argued cases with the Supreme Court, so not a bad way to start your Supreme Court practice. I'm going to skip. Oh, okay. Here's some other interesting findings. The lower court from which the most cert grants arose was the Ninth Circuit, probably not surprising there, followed by the Fifth Circuit, probably surprising there, and then the Sixth Circuit, another surprise. The lower court with the fewest cert grants was the Third Circuit, only 1. State court decisions resulted in 5 cert grants. The court with the highest affirmance rate, the 11th Circuit, 75%, followed by the 7th Circuit. No other court had above 50% affirmance. The courts with the highest reversal rates, First Circuit, Second Circuit, Ninth Circuit, and then sort of a surprise, the 8th Circuit. All of them had 100% reversal rates. So, and then on the merit docket, this is interesting and actually pertinent to what we're going to talk about. First Amendment cases, so free speech, free exercise, or establishment clause cases comprise 12% of decided cases. It may not sound like a high number, but only procedural and jurisdictional issues, which often sort of end up winding their way to this court, and criminal law cases ranked higher. So procedural jurisdiction had 20%, criminal law had 14%, and then following in third was First Amendment cases. And then of the 10 5-4 decisions decided the court, 7 were liberal outcomes and 3 were conservative outcomes. So again, some, possibly you might consider that surprising. And that was of the 10 5-4 decisions. There were 14, if you recall, 14 6-3 decisions. And in the 6-3 decisions, all 14 were conservative outcomes. So really, again, I'm a kind of a data and a stat geek, and I find that stuff to be very interesting. So what are my conclusions before I turn it over to John? I have 2 conclusions. Number 1, if you're an advocate before the court, it is less important to persuade one or more court's liberal justices. It is increasingly important to persuade the Chief Justice or Justice Kavanaugh or Justice Barrett. And here's why. Conclusion 2. Because statistically speaking, if you could persuade either of Chief Justice, Justice Kavanaugh, or Justice Barrett, you stand a substantial likelihood of bringing all 3. If you can get one, you're just statistically speaking, you're likely to get all 3 because they comprise the statistically strongest voting bloc on the court by a significant margin. So that's your little practitioner's tip to follow up with the stats. So, all right, for those whose eyes have glazed over because of like, why is he coming here to talk about numbers and percentages? I will now turn it over to Professor Blackman to talk about actual cases.
So let's do story time. Our story begins in 1973. Roe versus Wade. You may have heard of this case. The Supreme Court decides by a 7-2 vote that the Constitution protects a right to abortion. Which provision of the Constitution? They don't say. Might be the 14th Amendment, might be the 9th Amendment. Details are not important in the 70s. As I say, if you remember the 70s, you were not there. Roe was also decided by a number of Republican-appointed justices. Harry Blackman was a Nixon appointee. Chief Justice Burger was a Nixon appointee. Justice Powell was a Nixon appointee. The 2 dissenters were Justice Rehnquist and Justice White, who was a Kennedy appointee. In the wake of Roe, there was a backlash. The evangelical movement grew, and the Republican Party sort of gravitated around this cause. Reverse Roe. President Reagan came into office with the promise of reversing Roe. As it turned out, he would appoint 2 justices who voted to do the opposite, to reaffirm Roe. So let's go ahead to the 1990s. We have Planned Parenthood versus Casey. This was a frontal challenge to the Roe precedent. As I'm sure many of you know, the court didn't overrule Roe. it didn't exactly reaffirm it either. What the court said is we will keep the core holding of Roe intact, and we'll get rid of everything else. So there was still a right to abortion under the Constitution, but the sort of trimester framework was out. Instead, the new rule said if you're before the point of viability, the government cannot impose an undue burden on the right to abortion. And the Casey test itself was somewhat tricky to apply, but I want to focus on another aspect of the case. The majority opinion was fractured. There was a 3-justice plurality by Justices O'Connor, Kennedy, and Souter, all appointed by Republican presidents. Look who we have here. Look who the cat dragged in. My goodness. Did I let anyone in this building? Anyone's allowed in. My goodness. Okay. Welcome, sir. So there's
Now it's a party.
Now it's a party. So there's a 3-judge plurality by Kennedy, O'Connor, and Souter. And they explain why they're maintaining Roe. And their reasoning focused on this concept known as legitimacy. And what is legitimacy? What the court said through these 3 judges is that when you have a decision of the court like Roe, that's of severe, substantial, and then it's reversed simply because for different judges of a different political philosophy, it looks bad for the court, that the court's legitimacy might be. And then the court talked about stare decisis. They need to stand by precedent. And even if Roe was wrong in the first instance, there are reasons to stand by the precedent to create stability in the law and to avoid creating this impression that the courts are just extensions of the political process. Right? So Casey was 5-4. Right? So the Roe precedent survived. Conservatives were not done. In the wake of Casey, there was a mantra: no more suitors. Right? That's what we said for decades, to avoid having another Republican appointee who would vote to reaffirm Roe. Fast forward to the Bush years. President George W. Bush appoints John Roberts to the Supreme Court, seen as a solid, rock solid, right, Michael? Rock solid conservative. Then he appoints another person who actually lives pretty close here, named Harriet Miers. That didn't work out well. This was Bush's private lawyer. This is White House counsel. She had to sort of fade away, and Sam Alito was appointed. Now, what's not well known is that Justice Alito wrote the lower court opinion in Casey, the Third Circuit, that upheld the Pennsylvania abortion laws. So it seemed that you now had at least one more judge willing to get rid of Roe. We have some more appointments. We have Justice Stevens and Justice Souter step down back to back. We get Justice Sotomayor and Justice Kagan. They were never going to rule Roe. It wasn't going to happen. But then we go to February 2016. In Texas, as it were, West Texas, there was a hunting cabin. Justice Antonin Scalia was there for a hunting vacation. He went to sleep there, did not wake up there. He passed away in February 2016. Almost immediately, the Republicans in the Senate said, we will not give a hearing, let alone a vote, to anybody that President Obama chooses to nominate. No one's getting a hearing. President Obama nominated Merrick Garland. He's like the Susan Lucci of the Supreme Court. He always gets nominated, but he never gets through, right? He was in the short list several times. Poor Garland. Now poor Garland. Short today. He's a glutton for punishment, this guy. So Garland never even gets page 1. He submits his application and sort of sits in a pile somewhere in the corner. And then Trump puts out this list saying, if you vote for me, I will pick someone from this list. And you can trust me. Fun fact, no one of the 3 people he picked was on that first list. So this kind of list is garbage, right? If only you pick people on the first list, we would be much better off. But anyway, I digress. That was a good list. That was the OG list, right? That was a good list. Every other list just was like, it's like 30 people. Everyone's on. Are you on that list, Michael? I think
I'm on a list. Not that.
I'm on the blacklist, I think. All right, so fast forward. So after Trump wins, we get Neil Gorsuch. A year and a half later, Justice Kennedy steps down. We get Brett Kavanaugh. And then September 2020, on the eve of the election, Justice Ruth Bader Ginsburg suddenly passes away. Do the Republicans wait till after the election? No. They cram Amy Coney Barrett in like 5 seconds. I'm only slightly exaggerating, but she was confirmed like in 20-something days. It was amazing. Why am I telling you this story over the course of 50 years, right? Each of these things had to happen perfectly to get to where we are today in abortion. If any one thing happened differently, there were not enough votes. Mississippi, good friends to the east, enacted a law that bans abortion at 15 weeks. This law is clearly in violation of Roe. No matter how you count it, viability is not 15 weeks. Even the most miracle of science, you can't have viability of 15 weeks. The purpose of this law was to protect fetal life, which you cannot do under the Roe precedent and the Casey precedent. A number of the sponsors of the bill said, hey, but wait a minute, we got a new Supreme Court. And they were pretty candid about that. Case goes to the district court. Shocking, the district court says unconstitutional. Goes to the Fifth Circuit. Fifth Circuit dragging the heel says, well, we got this precedent called Casey. We don't like it, but we're bound by it. And it goes to the Supreme Court. Now, I don't know what Michael thought, but I was pretty confident there was no way the court would overrule. Maybe I'm just a pessimist. I don't know. I didn't think they had it in them. But the case was argued in December of 2021, or just last winter, just about a year ago. And the arguments are pretty straightforward. Roe was wrong. It was about a virtual meaning. Under principle stare decisis, the case is proven unworkable, unmanageable. It's created confusion in the lower courts. There's no legal reason to keep it. On the other side, they said there are very good legitimacy concerns to keep it. That if the court overrules Roe because of the 3 new Trump judges, if I can say that, it's one in this room, in fact, right? If there is overruled because of these drafting, these darn Trump judges, the court will look as just an extension of the political process, and the court will lose its legitimacy. The court will look like just another political branch. And that stare decisis, Michael gave some terminology. So, stare decisis is a Latin term. It means you stand by the decisions of the Warren and Burger courts. That's what the phrase means. So, if we stand by the decisions of the Warren and Burger courts, we'll look like the being principle. And there was an all-out attempt to, persuade the conservative judges, like, don't do it, don't do it. The court will be packed. They will add 15,000 seats. Everyone in SMU Law School will be Supreme Court justice. Congratulations, you are now a member of the Supreme Court. The Star Wars Galactic Senate, right? There were all these attempts to try to create a constellation of pressure on the court. And then we get to the spring. We get to April of 2021. By that point, the case had been argued. They discussed it internally in a conference. They voted internally, and draft majority opinion was circulated. And then the darndest thing happened. Who knows? Somehow, Politico, through who knows what means, came into possession of the draft majority opinion of Justice Alito, 100 pages long. Did you read the entire draft? I did. It was long, and I'll tell you, very little changed to the end. We'll get to that in a bit. Now, why was this opinion leaked? I think that's also an important narrative to discuss. We don't know. The Supreme Court apparently has a mission, who is the commission, looking into things to figure out who leaked it. But whoever sent that to the press was trying to do something. They were trying to affect the outcome, maybe make the conservatives blink, maybe make the conservatives entrench. Maybe it was designed to just burn the court down and say, screw it, you guys are going to overrule Roe, we're going to overrule you. So we don't know why, but the majority opinion, the leaked opinion, had 5 votes to overrule Roe. And this created a cataclysm of protests. Every night, people would stand outside the homes of Brett Kavanaugh, Tony Barrett. John Roberts didn't get too much. Even though, Roberts lives a couple blocks away from Kavanaugh. They were really close to each other. I guess they couldn't find Roberts' house. It was really on the Kavanaugh home and the Barrett home. And they both have young children. And I don't really care what you think about politics, but there's a cost when you keep telling people they can protest outside their house. And then what happens? A person gets in a plane, he has a suitcase, What's in the suitcase? A gun, a knife, some pepper spray, padding for his shoes. Because when you want to assassinate a Supreme Court justice, you don't want to make a lot of noise. He actually had padding for his shoes. And this guy shows up at Kavanaugh's house in the middle of the night when he was home with his wife and kids, walks up to the front door. He sees security. And then he says, uh-oh, I don't want to do this. So he walks down the block, he walks back, he does a stroll. I don't know what this guy's doing, right? And eventually he calls 911 and says, yeah, so I came here to assassinate Brett Kavanaugh, I changed my mind. So if you remember criminal law, like how much of a material step to become an attempted murder, it's actually a very hard question if you actually took enough steps. I think flying to Maryland with a gun in your backpack and walking to the house is enough, but who knows, it's Maryland. I don't know. Right? Don't give up gun rights in Maryland or attempted murderers, I think. I don't give you this lightly, but I'm just trying to make a point. Every ounce of pressure in our society was directed at getting Brett Kavanaugh. Michael said Brett Kavanaugh was a swing. He is. If Brett had changed his mind, Bro would still be with us. And for whatever reasons, I don't think we'll ever know, Kavanaugh stayed where he was. And he cast the deciding vote to overrule Roe and Dobbs. So the majority opinion was long. Oh my God, it was almost 200 pages. All the majority dissent was almost 200 pages long. I read it almost one sitting. It was painful. I read it so you don't have to. You're welcome. But the majority was fairly straightforward. They said there's no basis in the text history of the Constitution for abortion, no basis whatsoever. Stare decisis does not command staying by this precedent. It's proved unworkable. The standard has not been manageable. Without reliance interests, haven't women relied on abortion? What the court says is, yeah, no, that's not what we meant reliance. Reliance means like property contract interests. To the extent that women rely on it, well, now you don't have it anymore. The dissent launched a full-scale attack on the grounds of legitimacy that the court will be tarnished. If you've noticed, Justice Kagan's been on the stump recently. Anyone who gives her a microphone, she says the same thing about legitimacy. I think Justice Kagan's realized she can't persuade people in the court, so she's going to the court. That's her new thing. She'll go criticizing the court every chance she gets. I don't think it's going to work. It just backfires. I think it sort of hardens their heart. But the new world we're living in, and you guys in Texas are in ground zero for this, is that abortion restrictions are subject to a rational basis standard. Texas has in effect a complete ban on abortion now. We've had it now for, depending how you count, almost a year. The lingering issues will be traveling. Will states start prosecuting people who travel to other states to perform an abortion? Will they start hauling into court funds that fund abortions in other states? Will there be attempts to criminalize the shipment of various pharmaceuticals or medicines that could be used to perform abortion? What about advertising? You put a billboard on I-45 saying, come to New York for an abortion, right? Is that protected speech, or that's something Texas can criminalize? There are a lot of lingering constitutional questions that are not going to be answered by the Dobbs case, but the rule itself is now fairly simple. Abortion is not a fundamental right, and the state can do about whatever it wants. There's still state constitutions, which might be amended or changed to protect an abortion, but under federal constitutional law, there's nothing there. All right, that's abortion. Let me talk about guns for a bit. People are not, yeah, guns, right? For the first 75 years or so of our republic, the Second Amendment didn't really, have much relevance. The federal government didn't really enact many gun control laws. In the 1960s and 70s, federal gun control laws became much more prevalent. This came in the wake of a number of assassinations of figures, RFK, MLK, and various very prominent figures. And throughout the 1970s into the 80s and the 90s, a body of scholarship began to develop, suggesting that the Second Amendment places limits on the government's power to restrict handguns. And this scholarship created an outcry, a stir. And there were two major camps, right? One camp said, no, The Second Amendment concerns militias. It speaks of the well-regulated militia. It's right of the militias to have guns, or maybe it's right of the people in the militia to have guns, but something related to militias, right? The specifics kind of vary over the years. And the other camp said, no, 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 no. The Second Amendment does not concern militias directly. It concerns rather the people, individuals, to keep and bear arms. And this debate was largely academic for a couple decades. Chief Justice Burger, that stalwart of conservatism, said the view of the Second Amendment's individuals a fraud. It's called fake news, right? It was fake news for the Chief Justice. But we get to the mid-2000s and we start getting decisions from the Fifth Circuit and other courts suggesting that the right to bear arms is an individual right. The issue comes to the Supreme Court in 2008, DC versus Heller. Can the District of Columbia ban possession of handguns in them? We're not talking about carrying a gun. We're not talking about having any rifles. Keeping a pistol in your home, is that a constitutional right? By a 5-4 decision, the court says yes, there is a constitutional right to keep and bear arms. Justice Collier says you have the Second Amendment. It's not about the militia, that's the prefatory clause that does not control the operative provision that speaks to the right of the people to keep and bear arms. The dissent by Justice Stevens, another by Justice Breyer, was very vigorous, saying, no, we're not originalists here. You gotta be an originalist. You have to see that it's about militias and the right of the state to protect their militias, not about the right of people to have handguns. That was Heller. 2 years later, we have McDonald v. City of Chicago. The Supreme Court holds that the Second Amendment is incorporated. So what does incorporated mean? It means the right that applies to the federal government also applies to the state government. It's a restriction on both government parallel in the same meaning. But neither Heller nor McDonald said very much about the scope of the Second Amendment. Not much at all. What they did say was, we're not applying a rational basis standard review. Sorry, a little warm. It's not applying rational basis standard review.
It's because we're talking about guns.
Yeah, so guns out. Right. I have no guns, not yet. Private university, right? The court says it's a rational basis standard review. It's not rational basis standard review, but it may be strict scrutiny, it may be intermediate scrutiny. It won't really tell you, it's up to you. Okay. The court also says in Heller, we are not challenging long-standing regulations on guns. For example, bans on guns in sensitive places. Felons can't have guns. And dangerous and unusual weapons, and not or, dangerous and unusual weapons are not necessarily protected, courts being. So in the wake of Heller, I got excited. I was like, man, this is awesome. We got a Second Amendment back. This is great, right? I was a 3L when Heller was decided, which I'm dating myself. In the years following Heller, the courts were like, yeah, that's nice, never mind. Almost consistently, lower courts applied this sort of intermediate scrutiny and upheld almost every single gun control regulation. And with the exception of Reed O'Connor and a few other people, every federal judge said, okay, that's fine. But pretend Heller never happened. I'm being somewhat sarcastic, but not very much. And then I kind of got sad. I look, we have the Second Amendment, and every single gun control law is being upheld. It's as if Heller never, right? You have a right to a gun in your house, and not much more. So then we finally get to 2000. New York State Rifle and Pistol Association versus Bruin. New York City has what was called, had what was called a may issue carry regime. What does may issue mean? Well, if you want a license to carry a gun, maybe we'll give it to you, maybe we won't. Depends on what, who the heck knows. It was a subjective standard. You need to show what's called proper good cause. Right, proper or good cause. Merely wanting to defend yourself was not sufficient. You need to show something above and beyond. Exactly what that is, it varied from case to case, county to county, in fact. If you're friends with the sheriff, you get your permit. If you're a celebrity, you get your permit. If you're a random guy in Rensselaer County, you ain't getting your permit, right? You're not getting your permit. So the case goes to the Supreme Court, 5-4 decision. The justices hold that the Second Amendment protects a right to bear arms, and that right cannot include the sort of discretionary may issue standard. The court, or Justice Thomas, holds that there must be a right to bear arms as an objective matter, that unless there's some affirmative reason not to give it to you, you get your license. So if you were criminal or fail a background check, you don't get your permit. The majority opinion by Justice Thomas was emphatically originalist. He says, when we're assessing modern gun control restrictions, we draw analogies. What similar restrictions exist in the past? And if there's no analogical antecedent thing you're else, right? If there's no similar law in the past, the current law must fail. Again, the dissent by Justice Breyer, basically his last real dissent, said that the Second Amendment is not about individuals, and that there's a long history of laws restricting carry for those who terrorize others, going back to the 1300s, the so-called Statute of Northampton. But again, he was in dissent. This was a 6-3 vote. That's the magic number, 6-3. So in the wake of Bruin now, we have just a raft, a litany of litigation. Just a judge 2 days ago, Judge Counts out in Pecos, a Judge Counts in Pecos, counts in Pecos, ruled that a person under indictment can still have Second Amendment rights. We're going to see challenges to carry bans under the age of 21. Why can't an 18-year-old carry? We're going to see challenges to different types of arms, various types of rifles. Non-violent felons. If you're Martha Stewart, you engage in insider trading, why don't you have the right to bear arms again, right? These cases will percolate for a while. And I should tell you that I was in Manhattan about a week ago, and I was there for a lot of reasons, but I went to Times Square for a specific purpose. New York City is designated Times Square as a sensitive place, so no carries allowed. Now, anyone ever actually been to Times Square? Oh, God bless you, Texas. Yeah, a couple of you. So usually I think of Times Square as like a 3 or 4 block area. They designated a 30 square block area as Times Square, as a sensitive place. And they said they would post signs at the perimeter to notify you that you can't carry. So I walked about 20 blocks till I found a damn sign. I found one already. It was a little, I swear to you guys, it looked like it was zip tied on the street sign. It was like on the light pole. It said gun free zone. If you look quickly, it says, oh my God, free guns? It's a free gun zone? No, a gun free zone. And then these little signs. So unless you live there, the Second Amendment just need not apply. Subways are off limits. Buses are off limits. Houses of worship are off limits. Even if the house of worship wants to have guns, they're not allowed to have them. That would be you guys, your religious liberty, that might be a fun issue to follow as well. I'll stop here right about 12:30. My good friend Michael will talk about some of the religious liberty cases on the docket, and then we'll come back to the Q&A. So thank you all so much.
Thanks, Josh. So yeah, I mean, while certainly Dobbs and Bruin were 2 of the blockbuster decisions of the term, that's not to say that the religious liberty cases on the court's docket this past term didn't also garner some attention. So I'm going to try to cover 3 of them in the time that we have. The first one is Ramirez versus Collier. Anybody even heard of the Ramirez case? Okay, so
very important case.
A smattering of hands, if that. Probably doing offense to the word smattering. And it was the one that was probably the most overlooked in terms of the the religious liberty cases. Quick background: John Ramirez and 2 accomplices tragically and horrifically murdered a convenience store worker in Corpus Christi, Texas, and all to steal $2 from the convenience store worker, and ended up on death row throughout a number of years. Tried a number of ways to either delay or not be executed, and eventually he had a case that made its way to the Supreme Court. He challenged a decision that went against him, and that under this federal law called RLUPA, the Religious Land Use and Institutionalized Persons Act. We could spend another hour explaining how we won. So, so John Ramirez proclaimed that he wanted his minister, right, a member of the clergy, to actually physically touch him and to pray for him while he was being executed. That was his claim, and that the state of Texas was denying this. And the state of Texas, its argument was that, well, it made a number of arguments, and I'm going to cover a few of them because they're pretty interesting, right? The first argument was, well, we can't allow the priest or the clergy member to lay hands and to pray over him because, and I want to make sure I get this straight, they said, oh yeah, that's right, silence is necessary to determine whether he's actually properly dying, right? So if the member of clergy is actually praying audibly, they won't be able to tell if he's praying. So I think that argument is interesting, especially in light of my, and I'm not trying to make light of the context of this case, but I sort of look at this as the welcome to the SEC argument, because the Supreme Court said, well, Texas, that's all well and good, but your counterparts to the east in Alabama, they got you beat by 1 point, and we get it? We got it? Okay. Because in Alabama, they allow a priest to be praying audibly in the execution chamber, and it doesn't seem to prohibit them from being able to determine whether or not somebody has been properly executed. So nice try. Oh, and also the federal government too also allows this. So why is it that Alabama can do it and the feds can do it? Somehow, state of Texas, you can't do it. So that one failed. And then Texas said, okay, well, let me try this, or let us try this. They said that it's possible that for safety reasons, that the priest or the clergy member might actually be smuggling in weapons or contraband, and we can't allow that. And thought, well, I actually thought that, okay, that sounds like a legitimate argument, compelling state interest there, right? Supreme Court said, okay, quick digression. You guys, anybody ever even heard of Looney Tunes? Okay, good. I'm saying north south. Okay, yeah. My favorite Looney Tunes episode ever is the one where Bugs Bunny and Yosemite Sam are playing poker. Has anybody seen this one? Okay, so Bugs Bunny, please tell me you know who Bugs Bunny and Yosemite Sam are. Okay, right. So they're playing
Yosemite
poker.
Sam got canceled, I think.
Oh no.
Yeah,
Okay,
that's
well. So Bugs and Yosemite Sam are playing poker, and Bugs Bunny, or Yosemite Sam, he kind of has that chuckle. Like, he goes, "I got 4 aces. Beat that, rabbit." And what does Bugs Bunny do? He does the Bugs Bunny laugh. And he goes, "Oh yeah? Well, I got 5 aces." Okay. That's essentially what the Supreme Court continued to do to the state of Texas. Every time Texas would put out an argument saying, basically, I got 4 aces, can't trump that, the Supreme Court said, we got 5 aces, or in this case, 5 votes, right? And so when Texas said, we can't allow him the clergyman to be in there because he might smuggle in weapons or contraband, and it would disrupt the safety and security of the environment that's necessary in a death row inmate. Supreme Court said, okay, what is your normal practice? Texas says he stands 3 feet away. Wait, so he can stand 3 feet away, he's not going to smuggle in something, but if he comes in and touches the guy, he might smuggle in something. All right, so you get what the Supreme Court was saying, right? So long story short, Supreme Court says, Texas, you have not satisfied your burden, right? You have to show under that weird law, RLUPA, that I mentioned, you have to show if you're going to substantially burden somebody's religious exercise, then you have to show that you have a compelling state interest. And yes, safety, security, all that is a compelling state interest. But there's another part of the test, Texas, that you haven't satisfied, and that is what's called the least restrictive means. In other words, the way that you're trying to accomplish that interest, right, is the least restrictive on the religious practitioner's religious exercise. In other words, there's no other way for you to do this. And as the court, as I've explained, right, the court went to show over and over why there are plenty of other states that are already doing what you're saying you can't possibly do. So surely this, there is a less restrictive way for you to accomplish your interest. Now, interesting takeaways from the case. First, Justice Thomas dissents, okay? And that in and of itself is usually a fascinating experience when Justice Thomas dissents, because he, I highly encourage you to read Justice Thomas's dissents over time, because they're usually enlightening and fascinating. And this one is no exception, because in his dissent, Justice Thomas says, I would vote against, I would rule against Mr. Ramirez for no other reason than really, I don't think he's sincere. Now that should catch your attention if you're a follower of religious liberty law, because usually the one area where courts don't go is questioning the sincerity of the practitioner. And I think Justice Thomas would agree with that. Normally we don't mess around with whether somebody's sincere or not, but he says, but in this case, the litigant has such a long and documented history of trying every way he could think of to delay or stave off his execution, that to include like only bringing up at the literal and proverbial 11th hour, that this, for the very first time, that this is now all of a sudden a very important part of his faith, that somebody actually touch him and pray over him, right? He hasn't been making this request for I think it was 18 years that he's been on death row. Why hasn't he been repeatedly making this request? So while this was one of those cases where I'm just speaking for myself here, I sort of like, I think I agree with the court's majority, but boy, Justice Thomas just make a really good point.
I'm with Thomas.
Yeah, that and so it may just be an anomaly. Now, the other really interesting thing about this case was that the state of Texas, in addition to the arguments that I've already explained, one of the arguments they're making too is, you got to give some deference to our government officials, the corrections department. I mean, they're in the trenches, if you will, every day dealing with death row inmates and prison security. They know about prison security and how dangerous it can be in there. Give them some deference. And the court essentially said, yeah, I just don't buy it. I just don't think that they're entitled to that kind of deference. Which I think most of us, especially if you're on the conservative side of the ledger, you probably say, yeah, I agree with the court sort of having a skeptical eye towards the level of deference that the state is asking for. But then less than 24 hours later, on the so-called emergency docket, right? The emergency docket,
Shadow docket.
Some people may refer to it as the shadow docket. I will call it the emergency docket for our purposes. A case, and I'll give full disclosure, a case in which I'm counsel, was brought before the court, not by us, but by the other side, by the opposing party. The case is United States Navy SEALs versus the Department of Defense. And in this case, you have 35 Navy SEALs who have sincere religious objections to the Department of Defense's mandatory COVID vaccine requirement. And I'll skip over all the minutiae and just say we prevailed. We got a preliminary injunction at the district court. We then upheld that preliminary injunction. Fifth Circuit upheld the preliminary injunction on appeal. And then the Department of Justice, and actually the Solicitor General of the United States, who I referred to earlier, filed a partial stay in the Supreme Court, asking for the court to, in essence, allow the Department of Defense to not necessarily punish or separate members from the military, but to do things like reassign them or put them in a non-operational status for operational reasons, right? So in other words, let us make decisions that we think are best for the military that fall short of actually court-martialing or kicking them out. And the Supreme Court granted that partial stay. And in a concurrence, Justice Kavanaugh, who Josh spent quite a bit of time discussing his confirmation, Justice Kavanaugh said, look, we have to give deference to the government. They say they know what's best. We should stay out of it. So I just want to sort of, again, zoom out and say, okay, so on Tuesday, court says to the state of Texas, we don't really think you're entitled to the level of deference that you're asking for. Courts are well equipped to look into these things and determine whether or not you're entitled to as much deference as you say. 24 hours later on Wednesday, the court says, you know what? Government says that they know what's best and we need to stay out of it. So you guys get the deference and we're going to trust you. So I just thought that was interesting. right? So that was the Ramirez versus Collier case. Now, transition to another case. I'm going to cover these last two as quickly as I can. Carson v. Macon. You got to know the background of the case in order to understand why the case is fascinating. But before we get to Carson, you guys, does anybody know familiar with the case Espinoza versus Montana? I think it was like Department of Revenue or something like that. So Espinoza was a case in Montana. The down and dirty is Supreme Court ruled that when it comes to funding or religious education, right, that the government can't discriminate against a religious entity because of the religious entity's status as a religious entity. And there's this odd footnote that's sort of implied that there might be a status versus use distinction. What does that mean? Well, you're about to find out. So in Carson versus Macon, the case arose in the state of Maine. Maine is fascinating. Maine's kind of like the Texas of the North. Well, I guess Montana is, but okay. So it's like the Texas of New England, right? Because you have sort of these pockets of urban centers, but then you have a lot of rural area in Maine. Northern Maine is like very rural, so rural, in fact, that there are no public schools in certain areas because it just doesn't make sense financially, to try to build a school because the people are so scattered and live so remotely. But the state of Maine does say that because of the requirement to provide public education, that the people living in those areas, they get essentially a subsidy, right? The state will subsidize their ability to provide a public education. So instead of building a school, they'll just give you some money. Say, look, you can use this money however you want. You can send your kids to private school. You can send them to a charter school. You can even send them across the border to Canada, to an international school if you want. You can have them do online school. The one thing you can't do in the state of Maine is send them to a religious school, right? But then after the Espinoza case came out, it said, well, you can't discriminate against a religious school on the basis of its status as a religious organization. Maine said, okay, what we really mean is if you actually use the funds, right? Remember that status versus use distinction. So it's not based on whether the school has a religious status, it's whether they're actually teaching religious things. And I thought that was odd that the state would actually recognize what maybe some of us have recognized for a long time, that there are a lot of schools out there that are religious in name, not in actually what they teach, right? And the state recognized that. So yeah, if you're one of those that actually teaches religious things, you don't get the money, right? So First Liberty, again, full disclosure, my firm, I represented parents who wanted to use the money to send their kids to a school that actually teaches religious principles. And the state said, no, can't. Fast forward, bring a lawsuit, go through the district court, go through the circuit court of appeals, lose, get to the Supreme Court reverses a decision in Carson versus Macon. And they say, yeah, basically what we said in Espinoza, okay, it also applies to how you use the funds. The government cannot discriminate against a religious entity purely if the government has a scheme, right, where they're going to provide funding or they're going to provide some kind of general benefit to people. They can't excise out faith-based entities or the ability to use the funds to advance a religious purpose or a religious mission or religious education. And so, initially people think, oh, okay, well, that's kind of a nice quaint opinion that only applies to religious schools and private Christian schools. But I don't think it actually is limited to that. I think if you read the opinion carefully, which I encourage you all to do, you'll see that I think there can be much broader application to that. You could have faith-based organizations that have nothing to do with being a private school that say, wait a minute, we want to participate in this government program where the government's providing some benefit of some kind, whether it's funding or something else, and it's generally available to all sorts of groups, but for whatever reason, it's not available to a faith-based group. And one example that I came up with off the top of my head, just so that you can conceptualize it, is I happen to do a lot of work with faith-based organizations that try to help service members and veterans combating depression, mental health issues, traumatic brain injury, etc. And for years, they've been essentially stonewalled by the Department of Defense and the VA, saying, we love what you do. We really appreciate all the help that you're providing our service members and veterans. We can't work with you because you're faith-based, right? You drop the faith-based, we see what you're doing is highly effective. but get rid of the faith. And of course, what did the group say? Well, the faith-based component is actually that's the secret sauce, right? I mean, that's what their argument would be. So I think there's much broader application of the Carson case beyond just the school's context. Okay. All right. The final case, really easy one. Shouldn't take any time at all to cover.
Take a knee.
Yeah. Right. Kennedy versus Bremerton School District. Again, full disclosure, we represented Coach Kennedy.
They're good. They won a lot of cases this year.
It was 2 wins in 6 days, but I'm not. Who's counting, right?
He is.
So, and in fact, I'll be with Coach tomorrow at another fine institution of higher learning to actually talk about the case. So, Coach is I guess I can call him an old friend now. The case was going on for more than 7 years. So, the basic facts: Coach is a retired U.S. Marine who made a commitment. Right, he came to faith very late in life, after retiring from the Marine Corps. So, like, well into his 40s, right? He decides, like, I have he had a conversion experience. And right around that same time, he was offered a job as an assistant football coach at Bremerton High School. Does anybody even know where Bremerton, Washington is? Okay, across the Puget Sound. So go basically due west across the water from Seattle, Washington. And it's a little sleepy little town that the number one employer is the shipyard. Okay, if you know anything about shipyards, you're talking hard scrabble, blue collar, pretty rough and tumble town. Okay, and this is where he grew up. And his upbringing was no exception to that general description, right? Really tough upbringing. And he faith later in life. He was offered this job as a football coach. He said that he made a promise, a commitment, even a covenant, if you want to call it that, to God with his newfound faith that win or lose, didn't matter how the team played, after the game, he wanted to give thanks. Because he never thought that he'd be in a position to be a positive influence on young people's lives. And now here he is as a football coach. And so he just wanted to give thanks. Didn't matter how he played, he wanted to be thankful for that opportunity. And he felt as a Marine, the most appropriate time, place, and manner to do that was on the quote unquote on the field of battle, right? Right where the battle just happened. These two teams came in. This is coach's words. These guys came in as enemies, seeing each other as adversaries, as opponents. I want them to leave off as friends, right? And if somebody gets hurt, if quarterback gets hurt, and pray that he gets back on the field as quickly as possible. He would do this for about 15 to 30 seconds, take a knee. His intent was to do it by himself, but he said in his own words, if somebody else wanted to come do it to this free country, they can do whatever they want, or so you would think. School district tells them after 7 years of doing this, school district tells them, hey, you can't do that anymore, right? We've learned of your practice. We think it's actually a good thing. It's wholesome, no complaints. This is important. They did an investigation. No complaints, no evidence ever of any coercion, right? That, hey, Jimmy, you want to play this? You want to suit up this Saturday or Friday night? You better join.
Play or don't pray.
Right. I mean, no evidence of any of that, right? They said, but still, we're worried about violating.
Play to pray. I think that'd be it.
Yeah. We're worried, Coach, that you're going to violate the so-called separation of church and state if we allow you to do this, and we just can't take that kind of risk. So we're just going to tell you have to stop. And it's like he's wrestling with this. He reaches out to us. Hey, I'm just an old Marine. I don't, what are my rights? Tell him, well, look, can't lead students in prayer. I don't want to do that. Okay, good. You can't even really encourage them to pray with you. Okay, I don't want to do that. I just want to pray by myself. Okay, you have a right to do that by yourself. Ask the school for a religious accommodation. Ask them to accommodate you, to allow you to do this by yourself, 15 to 30 seconds, nobody else around you. School says, no, we can't do that. All right, we can't do that. So I'm watching the clock. So school back and forth over a number of months between us and the school district. Finally, they say, look, if you do this again, we're going to have to fire you. And coach says to me, I'm a Marine. Coach there, he goes, they messed with the wrong Marine. Right? I didn't serve for 20 years and deploy to the Middle East to have these rights, the very rights that I was willing to give up my life for, to have those rights taken away from me. So I I have to do this, right? I made a promise to God. I made a commitment that if I coach, I'm going to pray. So he went out there and prayed, fired. We sued. I actually ran the count the other day. Six times we had to lose, right? The Prime Minister Margaret Thatcher famously said once, sometimes you have to fight a battle more than once to actually win it. We had to fight it 6 times, right? District Court, Ninth Circuit, Supreme Court. Back to the District Court, Ninth Circuit, Supreme Court for the second time, right? And you're like, well, that's only 5. Where's the 6th one? We actually tried to get Ninth Circuit to hear the case on, which means instead of in front of a 3-judge panel, try to get all 28 Ninth Circuit judges to hear the case. We lost every single one of those before we got to the Supreme Court this term. And in what I would only describe as a blockbuster decision, they said, number 1, coach wins, school district loses. Number 2, the case that the school district and the lower courts 6 times in a row have been relying on to say that coach loses, a case called Lemon versus Kurdsmen, right? That case is gone, right? It's over, right? And so not only did it overturn what roughly 40-something years precedent that has been much like Roe versus Wade, has been a massive thorn in the side, but not of pro-life advocates, but of religious liberty advocates. It's gone. And they said, and the really cool part of the decision was they said, look, for too long now, the free exercise clause and the establishment clause have been viewed as being somehow in tension with each other by our courts. And that is unnecessary and unconstitutional. They're not intended, they were never intended to be in tension with each other. In fact, they work together, right? And they're supposed, and that's the way that our founders intended for the free exercise and the establishment clause to work together. So coach has the right under the free exercise clause to do that. And the school has no right under the auspices of the establishment clause to say that if he does it, he's fired. So where does that leave us going forward? I think if you take the Carson case, the Kennedy case, the Dobbs case, and the Bruin case, I think what you have wrap up here is sort of a new constitutional order in a sense. And I would say, and I would submit to you that the test that we're likely to see going forward is whether or not a right is fundamental. So that can include the right to pray, the right to have somebody pray for you, the right to keep and bear arms, the right to life. Whether or not that is a fundamental right is going to depend on whether or not it is a right that is enshrined in the history and tradition of our nation as understood by those who wrote the Constitution at that time. So I call it the deeply rooted, right? Is it a deeply rooted right that is consistent with the history and tradition of our nation? I think that is how we're going to see a lot of these cases play out in the near and hopefully distant future. And with that,
Questions, please.
yes, please, before Chick-fil-A.
Yes.
My question is for the law that just got approved for trial. Do you think that's going to make the Supreme Court, or how do you think that's going to play out?
Right. So if you couldn't hear, the question was of the Texas ban, of the Texas, which was it? Which suppressor was this?
No, one where they made it where press was made in Texas State.
Oh, yeah. Right. I mean, the idea is if you have a locally made suppressor is outside the scope of federal authority, that's not really a Bruin issue. That's more of a federal commerce clause issue. That is, were some parts in that law traveling interstate commerce. So I think that law is probably not going to go very far. Sorry. Yeah, in the front.
For Mr. Barry, is it?
Yes.
Okay. I wanted to touch on the first case that you mentioned, Ramirez. So from a religious freedom perspective, do you think that even if this guy